Bill C-45, the Cannabis Act, is a proposed piece of legislation that would effectively make the recreational use of cannabis legal to Canadian citizens. The bill has passed 3 readings in the House of Commons and has received critique from the Senate. Currently, the United Nations has 3 standing conventions that are antithetical to Bill C-45. This video will outline the international legal issues and problems surrounding Bill C-45 as put forward by the Senate Committee on Foreign Affairs and International Trade. There are 3 active conventions enforced by the UN that pertain to the legalization of cannabis: the Single Convention on Narcotic Drugs, the Convention on Psychotropic Substances, and the Anti-Trafficking Convention. Cannabis is one of the 124 illicit substances that has been deemed to have particularly dangerous properties and to present a serious risk of dependence and abuse with limited therapeutic value, according to the UN. The stated mission for these 3 conventions is the concern of member states for the health and welfare of humankind. Countries that have signed these conventions share a responsibility in their attempt to address the world drug problem. This is done by a commitment to prohibiting production, sale, distribution, and possession of psychotropic substances, including cannabis. The signatories of these conventions are obligated to limit the import and export of such substance to use for only medical and scientific purposes while combating illegal drug trafficking. The International Narcotics Control Board is the independent, quasi-judicial expert body tasked with monitoring and implementing the 3 conventions into practice. The board is composed of 13 members whom the United Nations Economic and Social Council elect for 5-year terms. The INCB acts in a personal capacity independent of any government, however they do engage in open dialogue with governments through consultation. All the witnesses that appeared before the Senate committee agreed that if Bill C-45 were passed, Canada would be in direct contravention of the UN conventions. The International Narcotics Control Board wrote an assessment to the committee. The following are excerpts from that submission. Bill C-45 is incompatible with the treaty obligations to which Canada is bound, and that any legislative measures aimed at legalizing and regulating the use of controlled substances for non-medical purposes as a fundamental breach of the international treaty provisions which state parties to the International Drug Control Conventions are held. Bill C-45 is also inconsistent with Canada's obligations to establish as a criminal offence the intentional possession, purchase, or cultivation of narcotic drugs or psychotropic substances for personal consumption. Some witnesses spoke to the importance of the basic principle of international treaty law and the insistence that Canada should support rules-based order, claiming that Canada is effectively deciding whether international law matters and to what extent. Some witnesses voiced concern, saying that there is the possibility that Canada could face political consequences if the Senate approves Bill C-45. One witness went as far to say that there could potentially be sanctions placed on Canada if the government goes through with legislation. Officials from Global Affairs Canada advised the Senate that Bill C-45 is consistent with Canada's compliance with the overall objective of the international drug control regime where the protection of health and the welfare of humankind is concerned. Some of the reasons for this include the level of violence and death associated with the illegal drug market, the corruption of institutions with drug money, the obstacles that prohibition creates for global efforts to combat HIV and hepatitis C, and the vast amounts of money spent on enforcement rather than treatment and prevention. A GAC official went on the records as saying, "A one-size-fits-all approach is unrealistic and that states need sufficient flexibility to adjust their policies according to the national circumstances and priorities." One witness testified saying, "Canada has sound reasons for moving forward now with this cannabis law reform for the health, security, and well-being of Canadians, even though doing so will inevitably entail non-compliance with certain drug treaty obligations. Canada could enact the non-compliance principle, whereby a state would admit to being in violation but still remains active on the world stage. This would mean moving to a temporary period of technical non-compliance with certain articles of the treaties, while proactively seeking to reform and modernize the outdated and malfunctioning drug control framework. Temporary non-compliance is a common avenue for the evolution of the international treaty system. Going forward, there are a number of potential ramifications Canada could face from the international community from legalization of cannabis, but many are adamant that the scope of the existing anti-drug conventions are not effective in their defined mission statement of protecting the health and welfare of humankind. Could this be a defining moment in the global shift on how psychoactive and illicit substances are viewed, or will it be a failed goal bogged down by red tape? Only time will tell.